Thank you, Patrick. All right, if you're going to take over the role of being the trustee after someone has died, you have to think in multiple time frames, because there are some time frames that you have to be aware of. There are things that you must do immediately or should do immediately. There are things that can wait till shortly after death. There are things that should be done within 30 days or 60 days. Then there's some real hard and fast deadlines at 9 months. And then there are the things that you conclude ultimately before you leave the stage as the trustee. Not everything has to be done at once. There's a logical order and timing to things. I usually tell my clients, you can't eat an elephant in one bite. You've got to take off one bite at a time and chew it thoroughly before you can move on to the next piece. So it's, I know that there's some urgency, usually on the part of the surviving spouse or the bereaved child, to get things moving. And it's a way of kind of covering up grief and getting on with things, and it's kind of making themselves feel better. But you really need to take the time to grieve with your family and friends before you move on. There is such a thing as what we call widow or widower's brain, and that's the reason why they tell you generally, as a rule of thumb, don't make any life-changing decisions for at least a year after someone has died. Give yourself a chance to kind of get your feet under you again and then make those decisions. Things you've got to do immediately. Review the anatomical gift instructions in the healthcare agent form. If someone has decided they want to be a organ donor, you want to know that as soon as possible. Review the memorial instructions and make funeral arrangements. Inform family members of your new role, particularly if you're not the surviving spouse and successor trustee. Contact relatives and close friends. Place the obituary. Locate military papers. As you know, any of you who are veterans would know you get certain benefits, including an American flag for the burial, if you let the Veterans Administration know that. And then, recognize again that there's time to act, take the time to grieve. Shortly after death, locate and review the estate planning documents. Meet with the attorney. Strauss Associates gives all of our clients and their families a free 1-hour consultation if somebody becomes disabled or upon their death, so that we can advise you of the steps that you need to take, and also of your options as to how to proceed, whether you feel like comfortable doing it yourself, whether you would want us to do it for you, what the pros and cons of that are. Sign the successor affidavit, trustee affidavit, if you're not currently serving as a trustee. Check the safe deposit box for important papers. File for the federal tax ID number. Your Social Security number dies with you. So after you're dead, you don't get out of paying taxes. Either you pay, if you died June 30th of a given year, then you're going to pay taxes under your own Social Security number in your name from January 1 to June 30th. From July 1st to December 31st, you're going to pay either in a probate estate taxes or in a trust the taxes for the income that is earned during that portion of the year. Open checking account in the name of the trust. Notify insurance companies and agents. Notify the company personnel department of all former employers. I recently had the experience of going back to a former employer of mine of some 20 years ago at the suggestion of one of my friends, because she had found out that she was entitled to some retirement benefits. So I went back and checked, and even though the company had been absorbed by another company, lo and behold, I do get certain retirement benefits from that company. That was a pleasant surprise. Notify Social Security Administration if necessary. Generally, it's not necessary. We'll go into that in a minute. Notify all advisors, legal, financial, and tax preparers, and order death certificates. We used to say 6 to 10. Now we say 4 to 6 is usually sufficient, because even if you send in what they call a raised seal death certificate, frequently if you give them a stamped self-addressed envelope, they'll send it back to you once they've made a copy of it. They just need to see the original. And they cost $10 now. They used to be $2. So we try to make best use of them. If the trustee is not the surviving spouse and co-trustee, collect and cancel all credit cards if they're not going to be used by the surviving spouse. file mail forwarding notice so that you get all the decedent's mail. Contact the bank for check writing authority and all open accounts. Now, within 30 days, you should identify, notify, and make claims to appropriate party that may pay burial expenses and death benefits. Beware again of the available veterans benefits. Advise the surviving spouse of rights of election and descent. If you are not the surviving spouse may not agree with the plan of the decedent. Maybe the decedent has attempted to completely disinherit his spouse. Hard to do, but they may attempt it. If you fail to advise the surviving spouse of their right to elect against that plan and take instead the share that the estate would allow you to take, then you have not fulfilled your duties as a fiduciary towards that surviving spouse, and you can be held liable. Begin your lists. Locate all assets and prepare an inventory. We recommend starting a spreadsheet showing the asset, how it is titled, and the date of death value for that asset. We recommend you do this even if this is not going to be a taxable estate. And as you all know, this year, the exemption for an estate is $5.12 million. So there's a lot of people who will not have taxable estates this year. But next year, that exemption is scheduled to return to $1 million. Say my decedent only has $600,000. You still want to capture those dated death values, first to establish conclusively that you don't have a taxable estate, and second of all, to make sure you capture what the new basis in that asset is. Everybody here understand what basis is in an asset? Well, somebody might be afraid to put their hand up. A basis of the asset is what you acquired it for. So if I bought Walmart stock for $10, that's my basis. If I sell it for $80, I've made a $70 profit. And on that profit, the government expects me to contribute a percentage for capital gains. If I instead inherit that, or my child inherits that Walmart stock, and it's listed at 80, and they sell it, they get a step up in basis to the date of death value. So if they sell that same stock at 80, they pay 0 in capital gains tax. Identify and list all liabilities and due dates, loans, taxes, etc. Maintain detailed records. If your attorney advises, file the original will with the county probate clerk and run the notice to creditors. The notice to creditors, and I know you've all seen these in the newspaper, what those do in the classified ads is shorten the statute of limitations for those claimants to come forward. These are unknown claimants. If you know that the decedent has received this bill, and you know that they ran up a lot of medical expenses right before they died, then you have to pay those known claims. But this is to cut off anybody who would say, oh, 3 years ago, Fred owed me money.
What is the statute of limitations now?
If you run the notice to creditors, it's 90 days. So that will significantly shorten it. Depends on what type of claim it is, what its real statute of limitations is. Make sure the liability and property insurance, as Patrick mentioned before, in terms of the estate for somebody who's incapacitated. Make sure that coverage is adequate. Review any business agreements. Provide notice to heirs and beneficiaries and known creditors. Meet with advisors about distribution of property and tax returns. Obtain the tax identification number for new trusts created under the living trust. If you set up a trust for each of your children, for example, each of those children's trusts has to have its own EIN number. Review with the tax preparer income tax returns for the trust, that's the Form 1041, and the last personal tax return of the decedent. Within 9 months, and this is where you get into some really hard and fast dates, the federal tax return, the Form 706, the North Carolina A101, must be filed 9 months from the date of death. And any taxes due have to be paid 9 months from the date of death. And if you have an estate in which you do not have much liquidity, there's not much cash in the estate, it's all real estate, then you're going to have to figure out a way to convert that real estate into cash to pay the IRS because they don't want a deed to property. They want cash. Disclaimers. What is a disclaimer? Anybody want to venture a guess? I know a few people know. Patrick knows. A disclaimer is a legal no thank you. No thank you, I don't want that asset. You say, well, why would I say that? Well, there are a lot of assets that people might not want. Particularly lately, I've been dealing with timeshares. I hear the laughs. The kids don't want them. Even the parents don't want them. So we disclaim them from an estate. That's the legal no thank you. Nobody can make you take an asset. Another instance where you might want to file a disclaimer is you have an IRA. And at the time of the death of one of the plan participant, the spouse is 95 years old. And the spouse says, well, if I keep taking these assets out of this plan, first of all, I'm going to be taking whopping big chunks of it at age 95. All it's doing for me is augmenting my income for tax purposes and throwing me into another tax bracket. And I don't need the money. If those are all the case, then the spouse may disclaim it. And when you disclaim, you can disclaim in whole or in part. It's not an all or nothing deal. You can disclaim half of it or keep only $100,000 of it, or however you want to do it. And that disclaimers apply to every single asset in the estate. And one more thing about disclaimers. If you do want to file a disclaimer, or considering filing a disclaimer, you can't take any benefit from that asset. So you can't roll that IRA over to yourself, take required minimum distributions for a year, and then decide that you want to disclaim it. It doesn't work that way. Once you've taken the benefit of that asset, then it's yours. Finally, once you have determined the value of the assets in the estate, filed any disclaimers if necessary, paid all the liabilities of the estate, including taxes, and concluded that no estate taxes due, or received a closing letter from the IRS indicating that the estate tax return's been accepted, then you can make distribution. That's our general rule. If the estate is very large, and you know you're going to have sufficient assets to cover all the liabilities and taxes and everything else, then we can start to use making partial distributions. So if you've got several $1 million and you want to distribute half of it out because you know you don't need all of that to pay the taxes and liabilities, then you go ahead and make a partial distribution and then wait and see until you get everything accounted for before you make the final distribution. Critical. Yes, ma'am.
What is the advantage of setting up a trust in your trust for your children?
What's the advantage of setting up a trust in your trust for your children? The big advantage is that you have asset protection. If you put your own assets into your own trust, that doesn't give you any asset protection. If everybody could do that, nobody could be sued for anything because everybody would do it. But when you set up a trust for someone else, then it's your rules that apply as to what those assets can be used for. I've never yet set up a trust and said, oh, pay his credit card bills, pay his judgment creditors, pay the victims of his crimes, pay his whiny ex-spouse, or any of those things. So if you set up a trust for the benefit of the children, the child can still be their own trustee. So it's like having your cake and eating it too. It's getting your assets tied up with a big bow that allows you to keep them and no one can take them away from you. Mostly I think that's a value worth preserving, particularly in the litigious times in which we live, and anybody can be sued for anything. It's better to get your assets in trust. I'd certainly prefer it, especially if I could be my own trustee, than have those assets given to me individually where they're subject to my creditors. Any other questions at this point? Okay.